So, in this video, we would like to discuss some other leftover leading cases under love contract, and those are relating to one is Lord Halsbury in Jansen versus Dread Fountain Consolidated Mines in 1902. The very fact of the case was relating to agreements opposed to public policy. So, the general head of public policy covers a wide range of topics. Agreement may offend against public policy by tending to the prejudice of the state in time of war, trading with enemies, etc., by tending to the perversion or abuse of municipal justice, that is, stifling prosecutions, champerty, and maintenance, or in private life, by attempting to impose inconvenient and unreasonable restriction on the free choice of individuals in marriage or their liberty to exercise any lawful trade or calling in a suit between private parties. The court will not enforce on the ground of public policy a contract which involves the doing in a foreign and friendly country of an act which is illegal by and violates the law of that country, and this doctrine of public policy is not to be extended beyond the classes of cases already covered by it. No court can invent a new head of public policy as it was expressed and held by Lord Halsbury in Jansen versus Dried Fountain Consolidate Mines in 1902. In the very decisions as rendered by the Court of Appeal. So, our next important leading case is case S.R. Chakrapani Chettiar versus Guru Swami Reddy in 1984. The Madras High Court held in the instance case as per A and B applied for grant of state carriage permits. Subsequently, they entered into an agreement that A would withdraw his application from one route and B would withdraw his application from another route. It was held that the agreement was not contrary to any provisions of the Motor Vehicles Act or rules thereunder, or was not violative of public policy or public interest, as it was held by their lordship of the Madras High Court in 1984 in this leading case. And the next important leading case is Central Inland Water Transport Corporation Limited versus Brajnath Ganguly in 1986. The Supreme Court expressed that Contract Act does not define the expression public policy or opposed to public policy. From the very nature of things, the expressions public policy opposed to public policy or contrary to public policy are incapable of precise definition. Public policy, however, is not the policy of a particular government. It connotes some matter which concerns the public good and the public interest, as it was held by their lordship of the Supreme Court in this important leading case, Central Inland Water Transport Corporation Limited versus Brajnath Ganguly in 1986. And the next important leading case that we would like to discuss is R.S. Devu versus M.B. Hindalkar in 1995, and the case was held by the Bombay High Court. So, in this instance case, the plaintiff, a customer, entrusted various clothes to the defendant who was carrying on business of cleaners, dryers, and launderers for drying, cleaning, and ironing. As a belly, the defendant was giving receipts for the articles received from the customers. Once the defendant failed to return some of the clothes entrusted to him by the plaintiff for dry cleaning and ironing, whereupon a suit was filed for recovery of damages for non-return of the clothes. The defendant, in his defense, relied on heavily on the laundry receipt, relying which contained a printed condition on its reverse, purporting to restrict launderer's liability for quantum of loss to 20 times the laundering charges or half of the value of non-returned articles, whichever was less. Whatever be the cause of non-return of the article entrusted by the customer to the laundry for purpose of laundering, the defendant was prepared to pay the amount of compensation as per the conditions printed on the receipt given to the plaintiff. It was held that the above referred printed condition was too wide, one-sided, and purported to restrict the liability of the owner of the laundry arbitrarily and unreasonably. It was also opposed to public policy and the fundamental principles of law of contract, and the same was thus void as per the provisions of Section 23 of the Contract-8 of 1872. No stipulation opposed to public policy can be given effect to or enforced by a court even where the stipulation is found to and have been assented to by the parties voluntarily, and the parties were sui juris. So, this was one of the most important cases relating to the principles as regarding opposed to public policy as it was held by the Bombay High Court in this very important leading case, R.S. Debu versus M.B. Hindalka. And now we'll go to another important leading case, and that is Birla Rangareddy versus Kalpalli Satya. And it was a case of 1883, and the very decision was held by the Madras High Court. So, as per the decision and as regarding to the fact of the case, a contract having stipulation to refer future dispute to arbitration is valid, but a stipulation that parties to a reference shall not object at all to the validity of the award on any ground whatsoever before any court of law does restrict a party absolutely from enforcing his rights on ordinary tribunals, and as such it is void. The courts have power in spite of such a stipulation to set aside an award on the ground of misconduct on the part of the arbitrator, as it was held by the Madras High Court in this very important leading case, Birla Rangareddy versus Kalapalli Satya in 1883. And now we'll discuss another important leading case, and that is relating to Messrs. Jamuna Auto Industries Jamunanagar versus Union of India and others in 1984, and the very decision was delivered by the Delhi High Court. And in the very instance case, the government entered into a contract for supply of goods with a contractor. Regarding supplies, an option was given to the contractor that they may supply 500 articles for months or 1500 numbers by 15th July 1973, and the balance by 15th May 1974. It was held that on account of this option, it cannot be said that the meaning of the agreement is uncertain and the contract was void for uncertainty under section 29, as it was held in this very leading case, Jamna Auto Industries Jamunanagar versus Union of India and others in 1984 by the Delhi High Court. And in our upcoming videos, we would like to discuss all the relevant problems that we have framed regarding law of tort and those important leading cases, as we have summed up in relation to law of tort.